I'm Joe Tucker, President of the International Academy of Trial Lawyers, and welcome to our podcast, The Rule of Law, The Academy Speaks. Today, I am so honored to have two former distinguished jurors, Judge Kathleen O'Malley and Judge Liam O'Grady, who spent decades on the federal bench at both the trial and appellate levels. And they are my Irish brother and sister. And they must know I've recently gotten back from Dublin, where I cheered on Ireland over Italy. Today, we're going to, first welcome, Your Honor. It's so good to have you here.
Thank you for having us.
Yeah, thank you.
Yeah, we're here during a time and period in our lives, in our legal judicial lives, that is, everyone keeps using the word unprecedented. I want to talk about what's going on today, what's going on in the court system. But I want to first begin with you, Judge O'Malley, and the idea and concept of judicial independence. What does that really mean from inside the courthouse when we talk about that?
Well, for judges, what it really means is that they are able to make decisions based on the law and the facts without any fear of retribution. I mean, if you go all the way back to our founding fathers, it was the king who they were trying to get away from when the king held up their pay and fired people who ruled against him. And that was part of our entire revolution and constitution. So what it means to judges is that they can make a decision and not fear for their families, their income, their livelihood, and they can know that no matter what they decide, it will be judged based on the law and the facts, and will be judged by any higher court that has the right to do that. And if not, will then ultimately be judged by history, but not affect how they live their lives and do their jobs.
Judge O'Grady, you served on the FISA court. And why don't you quickly tell some of our listeners what the FISA court is?
Well, the Foreign Intelligence Surveillance Act court was originated to allow intelligence agencies to get eavesdrop, if you want to call it eavesdropping, but to legally intercept communications in foreign lands originally, and so that they could determine whether there were threats against the United States, and the court does reviews surveillance requests now and every day, and the vast majority of that is surveillance on communications which are occurring outside of the United States, and if they're occurring inside the United States, it's with a foreign entity which has determined to be a threat against the United States.
Now, Judge O'Grady, when that court was originally set up and you were appointed by Justice Roberts, it faced much criticism because of what we'll call the spine. How does criticism from outside the court impact what you judges do? And I want you to weigh in on that also, Judge O'Malley, after Judge O'Grady.
Okay. Well, the FISA court is a little different. It's a hybrid. You're dealing with classified information. The court exists in a sealed environment in a corner of a federal courthouse, and all communications are isolated to that series of offices. The FISA judge decides whether there's probable cause to believe that the warrant should be granted. There is not the traditional review by a defense attorney, for instance. And when a search warrant is issued by a judge, a defense attorney has access to the affidavit in support of the warrant, and ultimately a judge decides whether there was probable cause and the search was lawful or not. In the
Well,
FISA
Judge
court,
O'Grady, that whole process of lacking what we traditionally think of due process
yeah.
was criticized from outside the court, from outside viewers and from the public. How did that impact your decisions?
It didn't at all. We are still bound to independently determine whether there's probable cause. There's a great deal of due process in the decisions that a FISA court makes. There's a review by staff attorneys. There's a review by the Justice Department when the affidavit comes before the affidavit comes to the FISA court, and then the judge reviews it to determine whether there's probable cause. So you don't have the traditional court system, but you have a good deal of review. The criticism which arose, some years ago over whether there was sufficient due process. I think that was looked at, it was reviewed further. Very substantial due process procedures were implemented to make sure that the decision that the FISA court made in any request was accurate. But no, the judge didn't change the substantive review that was ongoing. I mean, you would say you get 4 or 5 requests for warrants, and there's a tremendous amount of information that's available to the judge, and so that the judge can make a very sound decision. There's no guessing in the FISA court.
Let me turn to you for a second, Judge O'Malley. Today, judges, specifically federal court judges, are facing rhetoric that at times question the legitimacy of the courts. Some public figures speak of judges in personal or political terms. Before I ask you about, as a judge, how should lawyers and the public respond when the institution is being publicly criticized, and I would dare say diminished, when you have high public officials criticizing judges in the federal courts?
That's actually a very important question, because I think that the bar has a big role in this. I mean, there's a difference between criticisms for your decisions. I mean, I got used to that. You can't stay on the bench for decades without getting a lot of criticisms. People didn't like sentences I imposed or didn't impose, or decisions that I made. But you get used to that, and it rolls off your back because you have to ignore it. Your job is to do your job. But when the criticism becomes personal and becomes attacks both on the attacks that would make it unsafe for the judges and their families, but also are attacks on the institution itself, that is when it's extraordinarily offensive. That's why this institution, this group of Article 3 coalition judges exists, is to speak when the judges can't speak for themselves. And I firmly believe that the bar has a big role to play and should be outraged by what is going on and should stand up for the institution, because that institution is there to protect all of us. And it's not the judges against everyone else. It's the judges are here as an important branch of this three branches of government, and the lawyers need to say we all need to understand the dangers of attacking the institution.
Judge O'Grady, and what are some of the problems that you perceive when you have the president last Friday literally saying the Supreme Court was treasonous? That is, they were being controlled by foreign governments and foreign figures, that if a lawyer said that, he or she could be disbarred. But here we have the president behind the seal of the president saying things like that, in public. What does that do for public confidence in the courts?
Well, and Joe, it obviously erodes it, and that's why the confidence in the public today in the federal judiciary is down below 40% because of the confusion that politicians are bringing against the third branch. And the court is reactive. The court doesn't instigate a case. It brings its the cases come in, the courts review the law and the facts only in actual controversies. They issue their opinions. They don't comment on the side. I'm sure you saw recently that the Judicial Conference has loosened up the ability of judges to make some comments about, as long as it's limited to the rule of law or the importance of an independent judiciary, and which was, a significant change. But that doesn't allow them to say that the political world is, incorrect in what they're saying. We have the tension, of course, with the First Amendment that well.
Yes.
And where does it stop? But to move to impeach judges because you don't like the sentence that they imposed, as has occurred with a Maryland judge, or to have senators attempting to have a judge suspended from the bench because they don't like a proceeding that he has initiated and the cause for it. They just undermine the confidence that the public has in the judiciary, because the public doesn't know what the limits of judges are. They just know that they make decisions, lots of them unpopular, because of course somebody wins and somebody loses, as Judge O'Malley has said in court every day.
Let me turn to Judge O'Malley then about that. Judge O'Malley, how do we educate the public as lawyers, and in the case of you and Judge O'Grady as former jurists, how do we educate the public on the importance of the law and the independence of the judiciary? What should we be doing out here to let the general non-lawyer public know what's going on?
I'm going to get to that in 1 second, Joe, but I do want to respond to your last question too, because make no mistake, this is not the first president that has made injudicious comments about decisions that courts have rendered. But that was the worst example that I'd ever seen. And that he went so far as to personally attack the judges, say their families should be embarrassed. He called them treasonous, which then gives rise to other criticism. People think if he says that, then they can go after the judges. And it's not just the judiciary, but it's the judges individually that get attacked. So yes, you can always criticize a decision that a court renders. And certainly this president had the right to be unhappy with that decision. Probably not surprised by the decision, but unhappy about that decision. But it was the way he handled it that I think every public elected official needs to take a lesson on what not to do from how that was handled. In terms of
You
educating,
let me interrupt you there for a second. You would think that he would understand that he can't win every decision. This is the same Supreme Court that has given him immunity. So in this one on the Emergency Economic Act, they said no. And the way it almost reminded me of a child at a supermarket when their parents won't buy them snacks and they lay on the floor and scream and shout and just say all types of things. But here it was again, I keep saying behind the seal of the President of the United States, he made these statements about judges who I disagree with many opinions that they may issue. I like some, but you win some, you lose some.
well, there was a bit of so what have you done for me lately in the in the comments? I mean, he has won virtually every decision that the court has rendered, and of course, when he wins, they're great. So it does make his criticism a little even harder to take or to buy. But yes, it's important for him to understand that there are more decisions coming down the road,
Yes.
and why he would risk um, upsetting the justices even further. Uh, don't get me wrong, I don't think they care. I don't think they care what he said.
Well,
I think they'll just.
I'm not sure that, Judge O'Grady and Judge O'Malley, I'm not sure that. I remember when Barack Obama was president and he was criticizing the Supreme Court for the Citizens United decision. And Justice Roberts was sitting there in the very front seat, shaking his head, going, no, 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 that's not right. I mean, they're human.
In fairness to Justice Roberts, I think what he was shaking his head about and what was not right was not so much whether the decision should be criticized, but whether the President of the United States should be saying it in the public forum where he was saying it. And so I think it goes back to the institutional question. So you can, rightly or wrongly, in terms of how you feel about the decisions, it was wrong for Barack Obama to criticize him in that setting. And it's wrong for Donald Trump to criticize, and it's the same person getting criticized.
Yes.
But so I honestly don't. I mean, when I say they don't care, of course everybody cares when you're being criticized, but I mean it won't affect their decision making going forward, I don't think.
What do you say about that, Judge O'Grady?
Yeah. As Judge O'Malley said, this has been going on for decades. A new administration comes in, they have their own agenda. The agenda is tested in court. The judges rule, and there's criticism that comes out of that, and of course, our present administration has tested the limits, perhaps like no other administration has, but it's not the first. And judges we're going to be criticized, and we understand we're going to be criticized. And the difference now is the level of threats upon the judges, and the open season on judges, which has never been like it is today. And that's why the Article 3 coalition exists. That's why we've come together. The threat on the judges, and also the level of acerbic statements have risen, where there's a real sense that judges aren't as safe as they used to be. It's not going to change what they do, but it certainly is unfair, and it needs to stop. And education is the answer. In high schools and in colleges and in law schools and in bar associations, in Chamber of Commerce, wherever we can get the message out that judges are doing their jobs, they're doing the best they can. We have a great system. We've got district judges who collect the law and the facts. We've got a court of appeals which decides whether they have used the facts correctly and gotten the law correct. And if you don't like what the district court's done and the Court of Appeals done. You've got the Supreme Court to be the final decision maker.
Judge O'Grady, I want to thank you for that quick civics lesson, because there are many people who don't appreciate the civics behind that, because as I've often said, we don't teach civics enough in high school, which is, I think if more people understood civics and understood what was going on right now, they would be as concerned as you guys are. So
we don't
Justice
teach it
O'Malley,
at any level anymore.
Yeah.
That's actually probably one of my biggest complaints. That's one of the things that we need to do the most. I mean, when I kept saying this is basic civics, and I had a friend who reminded me, nobody knows basic civics anymore.
Yeah.
Which is why we need your organization, Joe.
Yes.
well, which is why we need you, because when you see your organization, you see judges spanning the political spectrum, and you have judges from courts, like yours, Judge O'Malley, which is a very unique court from the U.S. Federal Circuit Court, and who handled very unique and specific types of cases, which
And who decided the tariff case, by the way.
yes, I was. This leads me into that. What types of cases come in front of the Federal Circuit? Because most non-lawyers had not heard about the Federal Circuit Court until it decided the tariff case, which puts you in a very unique position.
That is funny, because having been on the district court for 16 years, where I decided all kinds of cases, then I moved to the Federal Circuit, and I had friends who were lawyers who even said, "What's that? What do they do?" Lawyers then tend to think that Federal Circuit is just intellectual property law. That's just one piece of their jurisdiction. They have a much broader jurisdiction than that, but they don't do any criminal cases. They don't do just basic diversity actions between parties from different states, but they have a range that includes intellectual property law, includes tax, includes veterans law, takings cases. There's a huge broad range, but international trade is one of the big things that they do. So that's how these cases landed in one of their lower courts and went up to them because of the international trade jurisdiction.